Hello, my name is Naomi Shipley. This presentation is for Arizona State University Masters of Science in Psychology program for Psychology 546, Advanced Forensic Psychology, and this presentation will be about the competence to consent to a search and seizure. The Fourth Amendment addresses the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures, shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Much of the evidence used in criminal proceedings is gathered through the process of search and seizure. The issues of consent become muddled for several reasons, to include issues of ambiguity and the perceived power which law enforcement officers hold. Concerns regarding the procedure of search and seizure occur because most individuals are not aware that they are able to refuse to consent to a search and seizure when in the presence of law enforcement officials. And the Supreme Court has ruled that law enforcement officers are not required to explicitly tell an individual that they can refuse to consent. Can consent be considered consent if it's coerced? The competence to consent is determined almost primarily on the extent of coercion law enforcement officers apply. A research study involving people simulating police confrontation found that fear was a significant contributing factor to consent in almost all instances. The court case of Ohio v. Robinette, 1996 decision required that law enforcement inform a motorist that they were, quote unquote, free to leave before engaging in a consensual interrogation or requesting consent to search. The warning essentially informed the citizen that they did not have to speak to the officer and could go about their business unabated prior to the law enforcement consent request. Slightly more than 1 year after the decision, the United States Supreme Court overruled the decision on federal grounds and remanded the case to the Ohio courts. On remand, the Ohio Supreme Court did not uphold the mandatory use of the Robinette warning on independent state grounds. The Robinette decision was short-lived, lasting approximately only 2 years. It was considered a close cousin to Miranda rights. According to the text, the most likely reason for individuals consenting to search and seizure despite not wanting to is that they believe they do not have the option, or that if they request to terminate the encounter would be construed by law enforcement as a refusal to cooperate, and that refusal may be met with negative consequences for them. But what about mental illness or incoherency? Addressing the Fourth Amendment and individuals with mental illness, Hernandez 2014 cites individuals with mental illness to be more prone to compliance of authority figures. She argues the need for procedural fairness, especially for those who require more support. The topic of competence to consent to a search and seizure led me to ask the following discussion questions. The first one is, can consent be given when the right to refuse consent is not explicitly stated? The second question is, can consent be given by an individual who is incapacitated in such instances as under the influence or mentally ill? And lastly, is it coercion or consent?